For more than 100 years, states like New York, California, and New Jersey decided who could carry a firearm and who could not. Permits were issued based on discretion, influence, and subjective judgment. Then, in June 2022, everything changed. In a 6-3 Supreme Court decision, the justices ruled in New York State Rifle and Pistol Association versus Bruen, a case that would trigger one of the largest legal shakeups in modern gun law history. That single ruling didn't repeal laws overnight, but it put more than 100 gun laws across the country under legal fire. Pushpin if you want real facts, real court cases, and real timelines. Subscribe now so you don't miss what's coming next. Warning disclaimer, I am not an attorney. This video is for educational purposes only. Gun laws vary by state and change frequently. Always consult official sources or a licensed attorney. The Bruen decision that started it all. On June 23, 2022, the Supreme Court issued a landmark ruling that declared New York's proper cause permit system unconstitutional under the Second Amendment. In a 6-3 decision, Justice Clarence Thomas, writing for the majority, made a statement that would reshape gun law analysis across the entire country. The court made it clear that gun regulations could no longer be justified using modern policy arguments, crime statistics, or government claims about public safety alone. Instead, courts were instructed to follow a new and much stricter standard. From that point forward, judges were required to evaluate gun laws based on America's historical tradition of firearm regulation, especially around the time the Second Amendment was adopted in the late 1700s. This meant courts were no longer allowed to balance gun rights against modern data or apply interest balancing tests that had been used for decades. Instead, judges had to ask one central question: did a similar law exist during the founding era of the United States? If the answer was no, the law could be ruled unconstitutional, no matter how long it had been in place or how popular it was. That single shift in legal reasoning sent shockwaves through the judicial system, triggering lawsuits, appeals, and challenges to gun laws across dozens of states. States rushed to save their laws. After the Bruen decision, states did not pause or hesitate. By July and August of 2022, several states with strict gun regulations moved quickly to respond. States such as New York, California, New Jersey, Hawaii, and Maryland began passing what lawmakers described as replacement laws, often referred to as Bruen response laws. These new measures were designed to preserve existing regulatory control while technically complying with the Supreme Court's ruling. The changes included expanded sensitive places bans, limiting where firearms could be carried, new permit and training requirements, increasing time and cost for applicants, enhanced background check procedures, adding additional layers of review. State officials argued these laws respected the court's decision while still prioritizing public safety. Gun rights organizations strongly disagreed, claiming the new laws were designed to bypass the spirit of the Bruen ruling rather than follow it. The result was immediate legal conflict. Within just a few months, dozens of lawsuits were filed in federal courts, challenging these new statutes and setting the stage for years of ongoing legal battles. Lower courts split apart. By 2023, it became clear that federal judges were no longer in agreement on how the Bruen standard should be applied. Courts across the country began reaching very different conclusions, even when reviewing similar gun laws. In states like Texas and Florida, federal judges struck down multiple restrictions, ruling that they failed to meet the Supreme Court's new historical test. At the same time, in New York and California, other judges allowed similar laws to remain in effect, at least temporarily, while cases moved through the appeals process. This lack of consistency created widespread legal uncertainty. Suddenly, the same type of gun law could be fully legal in one state, blocked or suspended in another, and under appeal in a third. For lawmakers, law enforcement, and citizens alike, the rules depended heavily on geography and judicial interpretation. By early 2024, legal analysts and court trackers reported that more than 100 gun-related statutes nationwide were either formally challenged in court, paused by injunctions, or under active judicial review. And that growing number is exactly where the headline comes from, not from a single ruling, but from a nationwide legal system struggling to adapt to a new constitutional standard. Supreme Court stays quiet, but powerful. In 2024, the Supreme Court played a critical role, not by issuing sweeping new decisions, but by intentionally doing very little. Rather than stepping in to resolve every dispute, the court repeatedly declined to intervene in ongoing gun law cases. It allowed lower court rulings to remain in place, even when those decisions conflicted with one another. By staying silent, the court effectively allowed the Bruen standard to continue spreading through the federal court system. This restraint was not accidental. By refusing to immediately clarify or narrow its earlier ruling, the Supreme Court forced lower courts to apply the historical tradition test on their own, even when the results were controversial, inconsistent, or politically sensitive. Legal scholars and constitutional experts began describing this period as a slow-motion restructuring of American gun law, not a sudden collapse, but a gradual, case-by-case transformation that continues to reshape how firearm regulations are judged across the United States. What states and courts are dealing with now. Now in 2025, the impact of the Supreme Court's shift is fully visible across the nation. What once appeared to be a narrow legal ruling has evolved into a widespread transformation of how gun laws are written, defended, and enforced. Across the United States, state governments are actively rewriting gun statutes, attempting to preserve regulatory control while reshaping laws to fit a constitutional test rooted in American history rather than modern policy analysis. At the same time, long-standing gun laws, many of them in effect for decades, are being lost in court, not because legislators chose to repeal them, but because judges concluded those laws could not survive the new historical standard. Other states are preparing for the next stage of the legal battle, drafting fresh appeals aimed at the Supreme Court, hoping that justices will eventually clarify how far the new standard should reach. Meanwhile, citizens are left facing ongoing uncertainty. Rules that once felt settled are now provisional. What is legal today may be blocked tomorrow, and what is permitted in one state may be prohibited in another. In this environment, legal outcomes depend on three critical factors: the state in which a case is heard, the judge reviewing the challenge, and how historical firearm regulations are interpreted. That is why the phrase, 100+ gun laws under fire, is not exaggeration or political rhetoric. It describes a real, unfolding legal reality, one that continues to reshape American gun law, case by case, court by court, and state by state. The Supreme Court did not erase gun laws overnight. There was no single ruling that wiped the books clean, but it fundamentally changed the rules of the game. And when the rules change, everything built under the old system is forced to stand trial, law by law, court by court. That process is still unfolding. This legal battle is far from over, and future Supreme Court rulings will ultimately decide how much of today's gun law framework survives, and how much is reshaped by history. If this breakdown helped you better understand what's really happening behind the headlines, please give the video a like. It helps more people find clear, fact-based explanations, court-driven updates on major legal and constitutional issues. Comment below, should history be the deciding factor for modern laws, or should states have more flexibility to respond to today's realities?